Howdy, and welcome to Patent Law, Week 4, Lecture 1. So this week we're going to be looking at some additional requirements for patentability. We're going to be talking about one substantive requirement today in this first lecture, and that's utility. And then we're going to be talking about three different procedural requirements. And by procedural requirements, I mean these are things that have to be present in your patent application, but it's really more a question of drafting the application properly than anything intrinsic in the invention or discovery you've come up with as an inventor. So let's jump into it. And so we've already talked about two of the three substantive requirements. You have to have something new or novel. You have to have something non-obvious, that is a non-trivial, not insignificant advance over the prior art. The third substantive requirement is it also has to be useful, and this is codified in Section 101 of the Patent Act, a new and useful invention. And so it has to have what we call utility. Now, if it doesn't have any utility, if it's ornamental as a design, you can seek a design patent. And for particular types of utility, such as a new hybrid species of plant, we have a specific plant patent that you can apply for and obtain. But even in the plant business, most of those folks who come up with new hybrids get utility patents for various reasons. So those are substantive requirements. And as I said, today's lecture, we're going to talk about what it means to satisfy the utility requirement, what is required to satisfy that element. Now, in addition, we're going to jump into what you have to include in your patent application. And I call these procedural requirements rather than substantive requirements. They're not intrinsic to the invention you've come up with. It's just how your attorney or the applicant has drafted the patent application. So you may have an invention for which you're entitled to a patent, and then you just need to draft the application correctly. And so these fall into really two categories, or at least it's easy to think of them as two categories. The first are set forth in Section 112A of the statute in the specification, the longhand description of your patented invention or the invention you want to patent. That description has to enable a person having ordinary skill in the art to practice it without undue experimentation. You must provide a written description of your invention, and you must disclose the best mode. Finally, your specification concludes with a set of claims, and those claims must be sufficiently definite so that we can tell what it is you're claiming. Can't say an elongated pole if we don't know how long the pole is. Does that mean 2 feet, 4 feet, 6 feet? Unless we can tell either from your specification where you can explain what you mean by elongated, or a person having ordinary skill in the art would be able to determine that readily. Your claim may fail for indefiniteness. So what you're going to talk about each of these this week, not really going to focus on best mode, and we'll talk in a minute about why. Okay, so again, as we saw for novelty and non-obviousness, these requirements can be enforced by the PTO examiner when you apply for a patent. The examiner can say, no, it's not novel, it's obvious, it's not useful, and so on. And then you can respond by amending your claims or rewriting your patent application entirely, refiling it, or you can argue with the examiner. We'll see that in the case for today. Then, if you can get it through the PTO and your patent application issues as a patent, when you sue someone for infringement or threaten to sue someone for infringement, then those same issues can be double-checked by a court in infringement litigation. They can also, since the AIA, be brought before the Patent and Trademark Office, before the Patent Trial and Appeal Board, the PTAB, in some sort of post-issuance review. Almost always inter partes review, but not necessarily. Now, one of the things the AIA changed, in addition to the other things we've already looked at, and is the reason we're not going to be looking in detail at best mode, is that the best mode requirement's no longer testable either in an infringement litigation or in post-grant review. The examiner can raise it on the initial application, but once it issues a patent, that issue is no longer present. And the reason Congress decided to remove it from infringement litigation is it made it very difficult to prove well, you don't have to prove a patent's validity because it's presumed valid, but to sort of remove challenges to validity on the summary judgment motion, because best mode was always in the subjective mindset of the inventor. What do they think of as the best mode for making their invention work? And so that always opened the door to discovery, deposition testimony, and made it difficult to resolve the validity of the patent in an early stage of the litigation. So it sort of led to fishing expeditions on what the inventor was thinking. So again, no longer enforceable on those grounds, but it's still a requirement of the Act. So it should be disclosed in the patent application. Okay. So when we think about these disclosure requirements and that we're going to get into this week, right? The casebook talks about 3 different purposes that these serve, right? So the enablement disclosure is the easiest to understand. There we're enforcing the quid pro quo of patent law, the bargain that the patent system strikes. You disclose your invention to us, we disclose it to the world in the patent itself, and in return, we give you this set of exclusive rights. And so we want that disclosure to actually enable people to practice the invention so they don't have to reinvent your wheel, right? They want to be able to build on what you've gone before. Some of the requirements tie into preventing premature patenting, and then some of the requirements, as we'll see, prevent overbroad patent claiming. So that's sometimes a little tricky to define. Okay, so we'll see these policies as we go through the various provisions. And again, courts today don't just read the statute and say, what do these words mean? They try to get at the gist of what it is that Congress was trying to accomplish, what is the reason for these various requirements, and then interpret the language of the statute to achieve the purposes that seem to be behind the provision. Okay, so today we're going to talk about the utility requirement. And so this is the requirement that the patent must be useful. The invention must work, it must do something. Now, it doesn't have to work well, and it certainly doesn't have to be better at solving a problem than existing technology. As long as it solves the problem, however expensively or inefficiently, as long as it actually does something, does what it claims to do, then the invention is going to satisfy the utility requirement. So it tends to be a fairly minor requirement in most circumstances, but not always. Every so often it'll rise up, and then you have to deal with it within the confines of the patent system. So 2 of the areas where we seem to have a little more bite with utility is the notion that you must have credible utility. If you make claims for your invention about what it's going to do, those claims must be credible. And so one of the rules under that sort of interpretation of the doctrine is that the Patent Office does not give patents anymore. They used to quite often. Every couple of years, somebody would come along and say, I've solved the perpetual motion problem. Here's a machine that generates more energy than it takes in or requires to operate. And so these sort of perpetual motion machines that periodically come up and people want to patent them. And so finally, the PTO said, we're just not going to give patents on this because none of them work. And the sort of modern manifestation of this is 0-point energy, energy from nothing in a sense. And so these violate various laws of physics. And so there's always a rat inside running on a treadmill to give the machine that extra energy. So it appears like it's generating more energy than it's taking in. So no perpetual motion machines. The other one that has considerable bite is that you must also show a practical utility. You must know what the invention does. So over the last 30 years, we've had a real rush to sort of patent various genetic strings, so sequence of genomes or DNA pairs on the DNA that code for different proteins or other chemicals in a body or cell when they're in the cell. But you can't just code for you can't claim a patent on a genetic sequence if you don't know what it does. And so that's a significant limitation on patenting in the biotech field. Practical utility, you must know what the invention does. And so that's what we see in the case involving the 318 patent. Now, I've talked about how in re or ex parte usually refers to an appeal from the PTO. And so it's the applicant on their own. And so there's no opposing party at the Federal Circuit level. Here, in re refers to the fact that we have multiple infringement litigations going on in different trial courts around the country. And so it's all getting sort of consolidated into one case for the appellate decision. So we call that consolidated appeal. Instead of calling it by each of the different party names, we say it's a consolidated appeal about the 318 patent. Now, the claim here looks entirely like the claims you see for pharmaceutical products generally, a method of treating a disease. Sometimes you can claim the compound, the pharmaceutical itself, the drug, but usually only when the drug is new. And most pharmaceutical treatments are actually not new chemicals. They're existing chemicals that have been well known, sometimes well studied for many years, but then it turns out that they're safe and effective for treating a particular condition. So the chemical here is galantamine. And so this was, again, a well-known drug, but even before this patent had been tested for various uses over time. And so what they're claiming here in the patent is, instead of the drug itself, a product patent, they're claiming a process patent, a method of treating Alzheimer's and so we've got our preamble, a method of treating Alzheimer's diseases and related dementias. We get our transitional phrase, which comprises, and then the steps, right? So a method is always a series of steps you take to achieve a different result. So you might mix this chemical at this temperature with this catalyst to get methanol from grain. Here we're administering galantamine to treat these particular diseases. And so the step is simply administering to a patient suffering from such a disease a therapeutically effective dose. So it's a process patent or a method patent. That's on its own not a problem. But the question was, right, had you shown a practical utility? Did we know that galantamine was going to be effective in treating Alzheimer's? And in terms of timing, right, lots of these requirements that we're going to be looking at this week tie to the date the application was filed, the effective filing date of the application. So the utility must be known or shown as of the filing date of the application. And so the question is, what was known at that time? Not when the patent issues, not what came to be known later in time, but what was known at that time. And here in January 1986, at best, the evidence suggested that this particular compound, galantamine, would be a good candidate for experiments to determine whether it would treat Alzheimer's, but it was not really known whether it would actually work or not. Some animal studies were eventually done, and they showed a favorable response for animals suffering from a similar condition, but that was not until after the application was filed, and indeed after it issued in May of 1987 as a patent. That was not known until July 1987. Again, the utility must be known or shown as of the filing date of the application. Okay, so a number of interesting things in this opinion that you should be aware of. So the examiner initially rejected the patent claims for obviousness. There was some scholarship, some articles in the academic press and scientific literature that suggested that galantamine might be effective for treating Alzheimer's and related diseases. And so the examiner said, well, if you look at these articles, they teach that this is a good compound to use for treating these diseases. The applicant, in response, right, so you can amend your application, you can file a new application, you can abandon your application. Instead, here they chose argument. And so you explain to the examiner, even if we look at the scientific literature at the time, it does not show that galantamine is going to cure or treat even Alzheimer's. It just suggested as a possibility, and so argues that it was non-obvious. That argument is in writing, and it becomes part of the file wrapper, part of the history of this patent. And so then it's approved for issuance and the patent issues. And that's important because it sort of comes back later on. So let's just talk about our time frame here. Now, the patent issues in 87, and then it's licensed to a pharmaceutical firm, Janssen, in 95. That's 8 years later. And then it's not until 14 years later, the FDA finally, we get the various trials done and the FDA approves galantamine as safe and effective for treating Alzheimer's. Not really that effective. So there's a process under the Hatch-Waxman Act, which is a provision that allows for early entry of generics in order to reduce the price of medications in our country. And what they do is they file what's known as a paragraph 4 certification with the FDA. And then they file, rather than a new drug application, which is what Janssen had to file, right? Janssen had to file satisfy all the FDA's hurdles in proving galantamine was safe and effective for treating Alzheimer's. The generics file what's called an abbreviated new drug application, or ANDA. All they have to prove is that their compound is the bioequivalent of Janssen's compound, right? Janssen's compound, we've already shown that works. We're the same compound. But filing this paragraph 4 certification amounts to an act of infringement under the Hatch-Waxman Act by statute. And so Janssen sues when those certifications are filed, or the FDA approves the drug, either one. And so Janssen then sues for patent infringement. And so that's how the utility patent issue comes before the court. Now here, right, in terms of describing what utility requires, you can see there's a very close link to enablement, though this is not an enablement issue, right? Here, the patent itself, it's well known in the relevant art how to create a therapeutically effective dosage of galantamine and to administer it. So there's no problem here with actually a person having ordinary skill in the art, learning from this patent, oh, I should give up Alzheimer's patients galantamine. But it's linked to it in the sense that both of them try to prevent patenting of mere notions or ideas. And so the appellate court here quotes from the earlier decision of the United States Supreme Court on this issue. Patent is not a hunting license. It's not a reward for undertaking the search, but compensation for its successful conclusion. And so it's not saying galantamine might work, but you've discovered that it will work. That's when you're entitled to a patent. Now, the court's a little careful to say you don't have to prove beyond all doubt. You don't have to get FDA approval to show that it would work before you can get a patent. So you don't have to get through phase 2 testing, human trials, or stage 3 as it's sometimes called. That is not required to to show that the drug has the utility claim. So what is required? Well, the court doesn't have to say exactly. All they have to say is you didn't have enough here. And so animal trials, in vitro, in vivo testing is animal trials. In vitro is sort of test tube testing of cells grown in the lab. Those might be sufficient. But again, the court doesn't have to lay down the exact rules. All the court has to say is this is not enough, and then not resolve some future case where we have animal trials or in vitro tests. So all I have to say is there's not enough at this time. And how do we know? Well, we go back to the prosecution, the file wrapper, and we use Dr. Davis's own words against her. She argued that the existing scientific literature did not make this an obvious discovery, did not show that galantamine was effective against Alzheimer's or make that obvious. And then now we turn her words against her. You said the scientific literature at that time did not show that this was going to be effective in this regard. And so there was no proven utility at the time, January 1986, that you filed your application. So this puts inventors in this area in a bit of a catch-22, right? No patent until you can show it works. You don't, incidentally, I should be very clear here, you don't need to know why something works. If your inventor cleans brass pots, you don't need to know what the precise chemical reaction is or why it works, just that it does work. But here in the pharmaceutical area, right, showing it works is very expensive, and you may need patent protection early to provide the incentive to cover the trial costs. And so that's why the Federal Circuit here says you don't need completed human trials, don't need to go that far. But if you don't need completed human trials, why shouldn't we give patents, in a sense, on hunting licenses, right? You've identified potential candidates. If you're going to do the work, you want the assurance you're going to get the patent at the end of the day. You don't want someone else to jump ahead of you in line and get the patent in your place. So why not give out these patents early? That is a good question, but right now the courts are saying not too early. Got to show a reasonable basis for knowing that it works. So at what point could Dr. Davis file for patenting? So what she did file for was when she believed the drug was a promising candidate for further testing. This case says that's too early. This case also says, though it's just dicta, not formally binding on later court decisions, you don't need human trials completed. What they seem to suggest is somewhere in the middle, and that might seem nice in a Goldilocks sense. But from a policy perspective, really the pharmaceutical companies may need the protection or assurance of the protection in sort of the first, when they believe the drug is a promising candidate for further testing, but that's not the outcome the court reaches here. And so why didn't Dr. Davis simply wait? Why didn't she listen to her lawyers, or did she got legal advice? She drafted a patent, filed it. If she had just waited until after the animal trials were completed, would the patent have been valid? Presumably yes. So why not wait? And there are really two reasons, right? One is priority. Someone else may jump ahead of you in line and patent first. And the second is validity. The longer you wait to file your patent application, certainly today when the effective filing date since the AIA, since March 16, 2013, is the filing date of the patent. That's the key critical date. But even back under the pre-AIA, the presumption was that your invention was complete as of your filing date. Now you could backdate it. You still also had the 1 year before your filing date. So the longer you wait, the greater risk of scientific publication or something else will come out that will count then as prior art because you're waiting to file your patent application and invalidate the patent on your discovery. So this puts you in something of a conundrum in the biotech pharma field as a patent applicant. Novelty, non-obviousness, priority being the one who gets the rights to the invention. All advise you to file early, and as a patent attorney, that's often what I'll suggest to you. But this utility requirement, and as we'll see, the written description requirement in the third lecture for this week, say, but you can't file too early, right, before you really can show that your patent works. Okay, so utility is the first of our sort of requirements that we're going to look at this week. Next up, enablement, which is probably the easiest to understand. Got to give an enabling disclosure, but we'll take that up in the next lecture.